Hey, welcome back. This is Estates and Trusts Online Module 7B. We're talking about marital property rights. In this section, we will distinguish between marital property ownership and spousal inheritance rights. We'll also take a look at some traditional elective share statutes and focus a little bit on the limitations of them. Okay, community property, again, we said this in the last one, is about ownership. Each spouse in a community property state owns 1/2 of all the property or money earned or acquired during the marriage. Non-married people can also accumulate property together. So this is about property ownership. We're focusing on who owns what. Each partner, of course, could leave his or her half to someone else. And partners in a non-married couple can also have separate property that they don't own together. The question is whether the state recognizes community ownership when the title is in the name of one person only. Okay, so take a look at Olver versus Fowler, page 291 in your casebook. This is a Washington state case. Washington is a community property state. And our two decedents are Gung Ho and Thuy Nguyen Ho. I don't know if I said that right, but they were not legally married, but they did live together. They had a religious wedding ceremony. They raised children together, and they acted like married folks. They had a family business, and they pooled all of their assets. Moreover, neither of them had much to begin with, so all of their assets were acquired as part of their partnership. They and several other family members died in a car accident. Now, both Gung and Thuy had wills. Each will left everything to the other, and neither of them had any contingent beneficiaries. Why? Why would you have a will and not put in a contingent beneficiary? Obviously, they had not seen King Ralph. So both estates are going to go by intestacy. And presumably their kids did not survive, because if they had, everything would be going to the kids from both sides and we wouldn't have this discussion. Most of the assets were titled in his name only. And if they had been legally married, all of their property would have been community property. So first, notice that the question here is whether Thuy owned part of the property that was titled in Gung's name, not whether she can inherit it. Now, the majority opinion applies community property principles to this couple because all of their property was jointly acquired. The dissent, however, says that this was a meretricious relationship and that community property principles should not apply for inheritance purposes, even though in Washington they would apply if they were dissolving their relationship. And there's a footnote that I find particularly offensive that points out that a meretricious relationship is one that's based on pretense, and I just have a hard time seeing any pretense here, but maybe that's just my blindness. Okay, so that was about ownership. Now we turn our attention a little bit to inheritance rights. Now we're not talking about intestacy, we're talking about a right to inherit part of your partner's estate regardless of the effect of a will. And so we start with the older doctrines of dower and courtesy. You can read about these in your casebook. Elective share is the modern version. Community property is about ownership. Dower, courtesy, and elective share apply in spite of who owns anything. They guarantee a survivor part of the decedent spouse's estate. Estate. Yeah, what do we mean by estate? Well, we've seen that there's a probate estate, an intestate estate, a gross estate, a taxable estate. You could make a song about all the different kinds of estate. Which estate do these rights apply to? Just the probate estate? Yeah, that's kind of what the court says here. But we know that it's easy to avoid probate. It's easy to not have a probate estate. All you have to do is transfer everything into joint tenancy or into an inter vivos trust, payable on death account. Just get it all set up, and you can easily disinherit your spouse. Now, a traditional elective share statute would only apply to a probate estate. In Bongards versus Millen, on page 300 in your casebook, the court talks about an earlier case, Sullivan, which had held that some non-probate transfers would be included in the elective share estate. I'm trying to get more in the sun so you can see me. So, for example, a trust created by the decedent. If the decedent had, say, kept a power of appointment or kept the right to revoke the trust. But this case was a little bit different. Because in this case, Jean, the decedent, did have a power of appointment, and she had the right to terminate the trust, but she had not created the trust. So she wasn't in this position because she was trying to disinherit her husband. Now, if this were treated as marital property on divorce, it would have been treated as her property. So maybe in that case, we should treat it as marital property at death. The court says, no, that's really not a good argument, because on a divorce, a judge will look at all sorts of factors in determining an equitable distribution of property. On death, we're talking about a bright line rule that's always going to apply. So this is different. Other arguments, maybe our modern notions of marital property really ought to apply here. The court says, yeah, maybe that's right, but the statute doesn't say that. It just says property previously owned by the decedent's spouse. That's all it applies to. The court focuses on the language of the statute and says there does not appear to be any ambiguity in the legislature's use of the term estate of the deceased. In context, it refers to the decedent's probate estate. The legislature should fix this. They say this in a couple of places. It is up to the legislature to choose between the complex options for modernizing this outdated scheme. And then later, our elective share statute has failed to keep pace with the changing principles on which the property rights of married couples are now based. In other words, get with it, legislature. Come on, give us a statute that makes sense now. But the legislature hasn't done that. Well, wait a minute. What about that Sullivan case we talked about? Didn't that depart from the statute? Court says, well, that was just plugging a loophole that allowed a spouse to evade operation of the statute. And here, Jean had not artificially tried to put property beyond the reach of the statute. What do you think? Are you satisfied? Didn't Jean effectively own the trust property? She could take it all for herself. She could leave it to anybody she wanted to. If she had creditors, they certainly could have reached it. Go post on Blackboard. Should an elective share statute reach property over which decedent had merely a general power of appointment? Or do we need property that the decedent originally owned? Okay, so to summarize these two videos, community property means the survivor owns half the marital estate. Elective share statutes, however, give the surviving spouse a right to inherit part of the estate, even if the decedent did not die intestate. And a traditional elective share statute only applied to the probate estate. However, remember, we looked at this in class, or we will if we haven't done this yet. The Uniform Probate Code includes a much broader array of property in the augmented estate. It takes a very modern approach to marital property ownership. Here's a surviving hedgehog. Thank you for watching. Come back for 7C.